Good evening and welcome to Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei with offices in Pottstown and Phoenixville. You can reach us by phone at 610-323-2800 or on the internet at owmlaw.com. My name is Joseph Koury, and tonight with me are my colleagues Jim Kovaleski and Gary Stein. Tonight we'll be talking about limited liability companies and some recent changes in the law regarding them, and we'll be contrasting them with traditional corporations, particularly from a management perspective, and hopefully give you some advice that will be practical to you in your daily lives. Why don't we start with the traditional corporation? And Jim, if I could pick on you, can you tell us a little bit about the management structure of a traditional corporation in terms of their different layers of authority, if you will?
Absolutely, Joe. It's interesting because no matter if you're Microsoft or you're a sole one member, one individual that forms a corporation, you're going to need a board of directors. They're the top level structure of the management. Beneath them are the officers, president, vice president, secretary, treasurer, that handle more of the day-to-day operations of the corporation. But like I said, whether you're Microsoft and you've got millions of employees, or at least thousands of employees, or you're just one person operating your own corporation doing some local business, you're going to need those two layers of structure of management for the corporation.
And I think there's a third layer that I would call the owners.
Yep.
In a corporation, a shareholder. Can you talk a little bit about that?
Absolutely. I don't mean to leave out the owners. So at the top of the pyramid would be those shareholders. So they're responsible for electing the board of directors. Board of directors, go a little bit more into it, governs the overall perspectives of the corporation, sets guidelines, things like that. And then again, the officers who are selected by the board, handle the day-to-day operations. So you've got your shareholder out there that really their main job for larger corporations is to elect this board. The board then sets the precedent, or sets the tone, or sets where the corporation is going to go, and then officers do the day-to-day.
So it sounds like there's a separation, if you will, between shareholders, directors, and officers. And I heard you say earlier that that's the same structure no matter if you're Microsoft or a mom-and-pop operation down the street.
Absolutely, and that's probably one of the more difficult and key concepts to get across to clients of mine is that an individual walks in, it's one person. That one person, if they want to form a corporation to conduct their business, they're going to wear multiple hats. They're going to wear the hat of the shareholder. They're going to wear the hat of the of the sole member of the board of directors, and they're going to wear the hat of all the officers, so president, secretary, treasurer. So they're going to have a lot of hats to wear, each responsible for doing different things for the corporation, and it's key to make sure that you're wearing the right hat for whatever action you're taking on behalf of the corporation. Otherwise, you can get yourself into some trouble.
Gary, can you talk a little bit to that last point that Jim just made? It's key that you wear the right hat when you're operating the corporation, so to speak, and particularly from a documentation standpoint is what I'm thinking of.
Yeah, documentation, and the risk, of course, is that if you don't handle things properly, that shareholders, officers, directors could subject themselves to personal liability. And that's what you want to avoid by taking advantage of the limitations on liability that a corporate entity affords you. But you're absolutely right. You need to comply with corporate formalities, and that means that you sign documents in your capacity as an employee or officer of the corporation. The management doesn't commingle corporate funds with personal funds. You make sure that every significant corporate action is authorized by the board of directors, that there's legal authority for the individual that enters into a transaction to do that. And if you go outside of the corporate aspect, that's what we call, it's a Latin term meaning ultra vires, you would subject yourself to personal liability. There are a variety of bad acts and misconduct then that can subject a person to a claim of piercing the corporate veil and resulting in the possibility of personal liability for what should be a corporate debt.
And is there any annual or ongoing requirement that's associated with the corporation?
Yes, there's a requirement that you have an annual meeting, and that means an annual meeting of the shareholders and an annual meeting of the board of directors. Unfortunately, a lot of people disregard those formalities. As I said earlier, it could result in a claim for breaching, piercing the corporate veil.
And is that the same even if one person, for instance, were the sole owner, shareholder, sole director, and president, secretary, and treasurer?
Yeah, the requirements are the same. You have those three levels, and I think, we need to make sure that parties respect the separate levels. You have the economic interest reflected by shares of stock. The shareholders then have to elect a board of directors. That's one of the main things they do at the annual meeting. You elect the board of directors, and then the board of directors has to meet at least once a year at that annual meeting, and then the board of directors has certain duties in terms of directing the decisions of the corporation. Now, those decisions may be implemented by officers, president, vice president, secretary, and treasurer, to name the main four. But yes, we need to respect those three separate levels and make sure that we always have sufficient documentation at those three different levels.
That sounds like a lot to keep track of, particularly for the small business.
It is a lot to keep track of, and that leads us right into the concepts behind the limited liability company, which we'll talk about for the balance of the program. But you're absolutely right. I mean, the LLC is a more streamlined entity, streamlined structure, streamlined decision making. It really is the entity of choice for small businesses today.
Do you agree with that statement, Jim?
Oh, absolutely. I mean, if you look at it from our perspective, even the formation process, when you're filing the original paperwork with the Department of State, is easier in the sense that you still have to file with the Department of State, but afterwards, you don't have to advertise. Corporations, you have to advertise in 2 newspapers of local circulation. There's no requirement for that for an LLC. So I agree wholeheartedly with Gary that, I like to use the phrase that they're much more user-friendly than the corporations.
That's an important point, and I don't want to trivialize it, but a lot of times clients are minding every dollar, so to speak, at the beginning of the entity's life, and advising of a couple $100 in in advertising costs, that hits the bottom line.
Absolutely, it does, and I agree with you. I mean, a lot of my clients, they're starting a new business, so they don't have they're not generating money yet, so they don't have a lot of money. So yeah, absolutely, every dollar counts then.
Now, jumping off of that and moving forward, Gary, can you talk a little bit about any annual maintenance requirements with a limited liability company, such as exists with the corporation, as we just talked about?
Well, there aren't any. There aren't any, at least, required. The limited liability company affords members a significant degree of flexibility. And let me talk about the structure, because the owners of the limited liability company are members, not shareholders. They don't get stock certificates. They have membership interests, and we will issue certificates that reflect the membership interest. But the phrasing is a little different. So the people that own the interest in the entity are members, and then we would go to management issues. And how is the LLC going to be managed? There are 2 possibilities. One is that the members themselves, the owners, will manage the entity as owners, as members. The other alternative is to appoint a manager. And a manager does not have to be a member, but the manager would be vested with the authority essentially to run or make significant decisions for the LLC. And that's a significant choice that the members would have to make very early on. It used to be that we would put in whether it's a member-managed or manager-managed LLC in the certificate of organization. with recent amendments, that changed. It doesn't go in the certificate any longer. It will go in the operating agreement. And actually, an operating agreement takes even more significance, takes on more significance these days because of the recent changes and pushing more and more aspects into the operating agreement. The operating agreement is essentially a combination of the bylaws that a corporation has and a partnership agreement, because that's what an LLC is. It's really a hybrid between a corporation and a partnership. So you take those two documents, the bylaws in a corporation, a partnership agreement for a partnership, and we've combined them into an operating agreement for the limited liability company. And it's really important to have that operating agreement customized for each individual business, because that becomes the most significant document to govern the affairs of the LLC.
You know, it's interesting you say that becomes the most significant document. As you were saying that, I was thinking to myself, this sounds like a partnership agreement. And you, in fact, alluded to the fact that a limited liability company is like
similar.
a partnership.
It is similar. I mean, among the important aspects you would have are management issues. All of the requirements relating to management will be in the operating agreement. There also could be buy-sell provisions in the operating agreement. So if you have more than one member, you really should have buy-sell provisions in that operating agreement.
And in fact, the new Limited Liability Company Act talks about transferring interests. It actually calls them transferable or governance interests. It's a new terminology. So I think to the extent that you want buy-sell provisions in the operating agreement to begin with, it becomes even more important now that there's this new sort of bifurcation, if you will, formally of what an interest can and cannot be in a limited liability company.
We're dealing with more complicated issues that need to be in the operating agreement, and frankly, there's no substitute to having that operating agreement prepared by an attorney, and that's what we do for our clients.
You know, and you had talked about a manager-managed limited liability company, and to the extent that the members aren't actually making decisions on behalf of the limited liability company, day-to-day decisions, meaning the manager is, it would seem to me that that would be critically important, particularly for those members, to have an operating agreement that they could look to understand exactly what the manager's authority is.
Absolutely. Whenever a question comes up, the first thing we would say is, let's look at the operating agreement, because that defines the rights and responsibilities of the members. And if it's a manager-managed entity, then it will also define the rights and responsibilities of the manager. And that document should be done immediately after formation, before there are any disputes with any parties. As I said, it should be drafted by an attorney, and we deal with those issues in the absence of any factual disputes. We try to bring our expertise and judgment to bear and prepare a document that doesn't favor any side, but that works best and has the best system to go forward in terms of the management of the entity.
Now, Jim, I think we heard Gary say that the certificate of organization, which is the document, the legal document that actually creates the entity, used to require the statement as to whether it was member or manager managed. And under the new act, that is no longer the case. Have you had any experience in the past, I'm thinking of banks, where they would want to see the certificate of organization to understand with whom they could deal, so to speak?
Oh, absolutely. We see it. I've seen it both in my capacity as an attorney and also as a title agent when we're doing new loans. Every bank that has ever loaned to an entity that I've been a part of, that's one of the first things they request is that certificate of organization, because they wanted to know how has it been structured. Who signed it? Who signed it as organizers? Does it list members? There's no requirement for it to list members, but I've seen some that actually have listed members. So they want that document up front. followed by the operating agreement, which I think now, moving forward, the operating agreement is almost as important, if not more important, than the certificate because of everything that it's going to include in there.
Well, it's interesting. And you mentioned certificate of organization listing the members, which I agree is somewhat unusual. But and Gary, you talked earlier about issuing membership units in a limited liability company. Another change under this new act is you no longer state on the certificate of organization whether membership unit certificates will be issued, whether it will be certificated or not. So I would think in that case, Jim, you're once again going back to the operating agreement to see who are the members of this limited liability company.
Absolutely, that's what I'm always looking for because I want to see who's listed in there, what percentages are there, what are they authorized to do, what are they not authorized to do. So again, I'm going to be looking more and more to the operating agreement to provide me the information that I need, whether it's, again, closing a loan as a title agent, whether it's doing some sort of negotiations or preparing documents on behalf of the entity in my legal capacity.
Gotcha. Gary, in talking before the beginning of legal talk, you described a lot of the amendments as technical, the amendments to the Limited Liability Company Act. And I agree with that statement. But looking at the other side, so to speak, one of the amendments talks about members' access to information in a limited liability company. And I'm not sure if you're aware of this, but an operating agreement can now restrict a member's right to information in the limited liability company, as well as restrict the use of limited liability company information by members. And that made me think of almost confidentiality provisions in a limited liability company operating agreement. Can you talk a little bit about just generally confidentiality provisions and how you might envision that impacting a limited liability company?
Well, confidentiality issues are significant, particularly relating to trade secrets or any issues that could impact the business. And let's assume you had a member that wasn't actively engaged in the operation of the business, that might be merely a passive investor. You would want to, or you could want to, let me emphasize that, you could want to restrict the use of very sensitive information from a member that really doesn't have a need to know. A passive investor would need to know economic issues, but not necessarily sensitive, confidential issues. So I can see the reason for that. What I would stress is that an operating agreement provides a lot of flexibility to the members. It's a contract. It's a contract between the members. And it goes beyond rights that would be afforded by the corporation's code. For example, you just referenced inspection rights or
Correct.
Rights that shareholders have under the law of Pennsylvania. Well, I can see why the recent amendments could restrict those because of the flexibility of an operating agreement, so that if the parties contract among themselves, and that's what an operating agreement is, they could certainly contract away some of those rights for a good reason, and if they're bargained for by the members. I mean, I think where you need to start with is that you'll have almost a blank slate, and that is it's a contract between these parties. What do they want to do, and do they have the legal authority to do so? And as I said earlier, there's much more flexibility with an LLC than there is with a corporation.
Jim, I'm not sure if you're aware of this, but flexibility, it made me think of this. I know you have experience forming nonprofit entities.
I do.
And there's actually, part of the new amendments is a change to the law in terms of what type of entity can be a nonprofit organization under Pennsylvania law. In fact, now limited liability companies can be nonprofit organizations.
I wasn't aware of that. Excuse me. But that's wonderful because that same user-friendliness that we've been able to offer to our for-profit clients by saying maybe an LLC is the right choice for you Now we can offer that to our smaller nonprofits that want to structure themselves like that, or even larger ones. But that's a wonderful change, and I think that'll be appreciated across the board by clients that are looking to form new nonprofits in the future.
You know, I always hesitate in the legal context to say one size fits all, and I don't mean that by any means, but I do think one of the words that you both said repeatedly, and with which I agree, is flexibility inherent to the limited liability company. But because of that, I think that it almost begs professional guidance because of the multitude of choices and structures and things that you can do with a limited liability company.
Oh, absolutely. I mean, if you look even on the tax, the way that they can be taxed, and that's not for tonight's
That's a topic for another night.
Absolutely, but there's flexibility even there that you can work with your accountant to make sure you're getting the best tax results, essentially, at the end of the day. So, yeah, LLCs are wonderfully flexible for clients, and that's a great thing.
Any closing thoughts, Gary?
Well, just on the nonprofit issue, I understand the desire for flexibility, Jim, in terms of some smaller nonprofits. Although, again, I would be somewhat skeptical in a more public nonprofit context, shall we say. I would see the need to retain a corporate structure with a board of directors and officers. I think that still works well in many nonprofit situations. So to follow up on your point, Joe, I would be hesitant about going with a knee-jerk reaction without thinking. And that's where the lawyer comes into play, is to meet with the client, evaluate the situation, and recommend the best business structure and provisions moving forward.
I couldn't agree more. Thank you, gentlemen. I appreciate your time.
Thank you.
This has been Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei, with offices in Pottstown and Phoenixville. We can be reached by phone at 610-323-2800 and on the internet at owmlaw.com. Thank you.